It's my grandma's dying, and that's it. Army infantry.
You were Army?
On the 24th of December, 2024, Dallas-Fort Worth Airport Police responded to a welfare call for an unconscious man on the airport concourse. The subject, a United States Army infantry veteran, was found passed out on the floor. He was arrested for public intoxication. 3 legal questions define this incident. Did probable cause exist under Texas Penal Code? Section 49.02, was custodial interrogation conducted without Miranda advisement? And was arrest the appropriate intervention?
That's what I was thinking.
He had like all this ash on him, and it didn't look like he's smoking cigarettes. So
Okay,
let me see if he's
gone.
still hanging out. Oh, see. Yes, sir. Not really. You don't think that's up.
Somebody's passed out?
I'm putting the gloves on.
Oh. Well, it's on the ground.
You guys are getting all the fun ones today, huh?
Yeah, we are. Hey, what's going on? Hey.
You okay?
Wake up. Wake up. Sit up.
Sir. Alright, I'm gonna do him on the side.
Yeah.
Alright, sir.
You call EMS.
Hey, are you alright, sir? Of course. You okay? Are you breathing? You okay? Yeah, of course. Okay. I just wanted to turn you on your side to make sure you're breathing. Are you experiencing any pain, anything like that?
No, sir.
What happened? Did you fall?
No, sir, not yet.
Not yet. Ed, before you can update, he is conscious and breathing.
Here, yeah, let's just have you sit down.
Sit down.
Yeah, I don't want you to get hurt.
Sit down.
Yeah, let's have you take your seat.
You good? Oh.
Alright, walk me through kind of what happened here. You didn't trip or anything like that?
Just taking that.
You were taking a nap.
So you weren't having any kind of medical emergency, anything like that?
No.
Just tired, wanted to get some rest?
Pretty much.
How much have you had to drink today? How much alcohol?
None.
None. Don't lie to me.
None.
Okay. You have your ID?
Man.
Why are there cigarette ashes all over the ground?
You been smoking?
Yeah, I smoke cigarettes, yeah.
Inside here?
No, not inside here.
That's not from your cigarettes? What are you giving me money for?
Didn't you just ask for me to Oh, goodness.
No, identification.
Yeah.
Do you know where you're at right now?
It's from the airport.
Okay.
Is that your ID?
I mean,
Is that your ID?
it's not an ID, but hell.
That's what I asked you for. Mm-hmm. We can cancel them.
Sir, would you like to be seen by EMS? Any medical services? Anything like that?
No, I'm fine.
You okay? All right.
So how much alcohol have you had to drink today? And I'm
Just
not
a
playing
glass?
these games with you. I know you're drunk.
Two? Well, what
I know
do you
you've been
have?
drinking.
I had me a beer or two, and that's it.
All right.
Okay.
Texas Penal Code Section 49.02 requires two elements. First, the subject appears in a public place while intoxicated. Second, and critically intoxicated, to the degree that the person may endanger the person or another. Element 1 is not in dispute. The subject was intoxicated in a public airport concourse. Element 2 is where the probable cause analysis breaks down. The subject was stationary, nonviolent, and immediately cooperative upon contact. He posed no proximate danger to bystanders. He was not near vehicle traffic, not exhibiting self-harm indicators, and not behaving erratically in a crowd. Texas courts have consistently required officers to articulate specific facts of actual or likely endangerment, not merely the presence of intoxication. A subject sleeping on an airport floor does not automatically satisfy that threshold. The second legal issue is Miranda. Under Miranda versus Arizona, before custodial interrogation, officers must advise a subject of 4 rights: silence, use of statements in court, right to counsel, and appointed counsel if unable to afford one. The lead officer asked directly, quote, "How much have you had to drink today? I know you're drunk," before handcuffs were applied. The subject then admitted to consuming alcohol. That admission forms the evidentiary basis of the arrest. The threshold question is whether the subject was in custody at the point of questioning. Under Berkemer versus McCarty, routine investigative questioning is not automatically custodial. However, the totality test applies. Here, the subject was seated on the floor, surrounded by multiple uniformed officers, and had surrendered his identification. Under Florida versus Bostick, the standard is whether a reasonable person would feel free to terminate the encounter and leave. On these facts, that standard is difficult to satisfy. Statements obtained in a de facto custodial environment without Miranda advisement face suppression under the exclusionary rule established in Mapp versus Ohio.
All right, go ahead and put that stuff back in your wallet.
Here we go.
And do you have your driver's license?
Yeah, right here.
Would you mind handing that to me, please? Thank you.
Just put your wallet down. Just put your wallet down.
Put your wallet down.
Just put your wallet down.
All right, sir.
You want to stand up?
I'm gonna have you stand up for me, please.
All right.
Oh. Okay. Your hands behind your back.
Well,
Yeah.
Thank you.
So you're under arrest for public intoxication
Okay.
at this moment.
Here we go.
So let go of your hands.
Thank you. Okay, let's.
Well, we have one in custody for public intox. Can we get a transport unit?
The third issue concerns the proportionality of the arrest itself. Texas Health and Safety Code, Section 462.041, authorizes a civil emergency detention alternative. Under that statute, a peace officer may take an intoxicated person into protective custody and transport them to a detox facility without filing a criminal charge and without generating a misdemeanor record. Public intoxication under Texas Penal Code Section 49.02 is a Class C misdemeanor, the lowest criminal classification in Texas, punishable by fine only. No jail time attaches upon conviction. The civil diversion pathway produces the same public safety outcome. The subject is removed from the concourse and sobered up without the downstream consequence of a criminal record for a nonviolent, cooperative individual. On use of force, the handcuffing technique was controlled and proportionate. Under Graham versus Connor, force is judged by objective reasonableness from the perspective of a reasonable officer at the moment of the decision. The subject offered no physical resistance. The level of force applied, soft empty hand control, and standard handcuffing was consistent. With a compliant, non-threatening subject, no Graham violation is present here.
Where are they?
Yes, sir.
That was today.
Did,
The
I
23rd.
did too. Oh,
Okay, all right.
yeah.
You guys are good.
All right, we're going to go outside.
Okay, I'm gonna go out this way.
You got it.
Yeah, I did.
Thank you, right?
20 days.
You alright? Whoa,
No, I'm fine.
don't want you to fall down. Oh,
Okay.
What branch were you in?
Pardon?
What branch were you in? You don't know?
No, I do know.
Oh, okay. Okay.
There's Army infantry.
You were Army?
Army infantry. I was just, I was told not to talk to y'all, but
Who's y'all? The police?
no,
No? Okay.
somebody higher up than y'all. But anyway, anyhow, no. I mean, I already told y'all.
Oh, okay.
I mean, I'm a real nice person. I don't,
Nobody's denying that.
Huh?
Nobody's denying that you're not a nice person.
No,
We
I
didn't
know.
say you weren't.
No, I know. But I've been real nice.
Okay.
I'm not trying to be a kid.
All right.
Is all I'm saying.
Okay. You just had a little too much to drink. So,
But that's the only reason that I'm just my grandma's dying and that's it. I'm not trying to
yeah.
I mean don't sit here and think that I'm trying to be a butthole, but I want to know what's going on. I really don't know.
So you're going to go to our jail at the airport.
Okay?
You're going to sober up.
Yes,
You'll
ma'am.
see a judge. And then you'll be able to be released. Okay?
All right.
You should be able to get your flight tomorrow. Okay?
Okay?
That's it. Yeah. You just got to sober up.
Am I able to talk to anybody on the phone
Yeah.
over there?
Yeah. You can make as many phone calls as you want. No charge.
Okay.
Okay.
Can y'all give me the phone so I can call?
No, we can look up numbers whenever we get over there, though.
Okay.
You can look up numbers in your phone.
All right.
Okay? You got to keep going.
Are you able to tell me what I did?
Yeah, you're drunk.
Okay.
You're arrested for public intoxication.
Okay.
That's what you did.
Okay.
Okay.
So everything that you already had said is just, giving me proof that I'm free to go. So, all right.
All right.
That's fine.
All right, stand up.
Okay. Oh, hold on. Give me 1 second. Oh my God. All right, I'm ready.
Just gonna walk right in front of the car, right?
It's late. Nah, we're good. And I have to wait for the report.
So, if you want to log in and start up the report and start your body camera, I can get it started for you.
He's trying to finish another one.
Okay.
Yeah. He was passed out.
Nice sitting out the neck.
It's supposed to be out early.
Spiking my blood pressure.
You're all right.
All right.
It's a backpack. Already put it in the back. It's in the trunk already. Camouflage backpack.
What do I do about that?
No, it's okay.
Wait, I don't.
7 minutes.
Hold on. I'm trying to.
I understand. I'll take care of it.
Would you be able to?
That's good.
My grandmother's about to die.
Backer, that's good.
Let's examine the constitutional framework. The lead officer receives a B. Her welfare-first approach, immediate radio communication, and professional demeanor throughout reflect solid fundamentals. However, conducting incriminating alcohol questioning without Miranda advisement and failing to articulate the danger element required by Section 49.02 represent procedural deficiencies that would undermine prosecution. The subject receives a B+. He complied immediately upon arrest, offered no physical resistance, and remained composed under significant personal and emotional stress. His primary legal error was answering incriminating questions without invoking his Fifth Amendment right to silence. The right to refuse self-incriminating responses applies at any stage before and after formal arrest. Dallas-Fort Worth Airport Police Department receives a B-. Officer conduct in this incident reflects good character and adequate basic training. No excessive force, no misconduct, no civil rights exposure. The department's gap is institutional in Miranda protocols for escalating welfare, contacts in probable cause articulation standards for the danger element, and in the absence of civil diversion as a documented field alternative. 3 takeaways from this incident apply broadly. First, public intoxication statutes require more than proof of intoxication. Officers must document specific facts establishing that the subject was a danger, not merely impaired. Second, when a welfare check transitions to investigative questioning about criminal conduct, Miranda exposure begins. The custody determination is objective. It does not require a formal arrest announcement. Third, civil diversion statutes exist precisely for situations like this one. A nonviolent, cooperative individual whose primary need is sobering up, not a criminal record. Knowing when not to arrest is as important as knowing when to. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.